The Madlanga Commission continues to unpack some of the deepest questions about policing accountability and just overall justice in South Africa. Let's dive into what transpired this week. Of course, we heard a testimony from key witnesses in recent days. This includes Lieutenant-General Nhlanhla Mkhwanazi, followed by National Commissioner Fannie Masemola, and then most recently, Major-General Petronella Van Rooyen of the SAPS Legal Division. Let's make sense of this. Professor Nirmala Gopal, UKZN criminologist, is going to be weighing in. Prof, on that note, a very good morning and welcome back. Thanks so much for your time with us here on the SABC at this hour.
Good morning, Liesl. Good morning to your viewers, and it's always wonderful to be part of your show.
So, Prof, we obviously saw what transpired this week, the witnesses testifying. I wonder if you could weigh in on some of the main themes emerging in their testimony this week. Perhaps if we're looking at, what has been revealed, how they've spoken about the culture within SAPS at large. Talk to us about that. I'm asking this because we're obviously looking for clarification in what has, led up to these events. And so we're wondering if there's still more questions and answers. What are the gaps that also still remain?
So indeed, Liesl, I think one of some of the main items that have actually emerged is based on, of course, the initial testimony or the leading testimony by Commissioner Nhlanhla Mkhwanazi. I think the fact that the National Commissioner corroborated his evidence, although there were, of course, some contradictions in terms of his role between the president and the instruction that came from Minister Mkhunu. So I think there were some contradictions that emerged there, and I think that's when the commission actually probed him even further. But that was an important piece of evidence. But outside of that, I think the fact that Van Rooyen, Advocate Van Rooyen, has also corroborated General Mkhwanazi's evidence. And yesterday's evidence by Advocate Elaine Harrison that further corroborated the evidence. But I think at this point in time now, what the rest of South Africa and the global world are actually waiting for is to hear the other side. So it's the rule of audi alteram partem, which in this case would mean Minister Mkhunu himself, the president, of course. I think everybody's waiting to hear what the president has to say, given the fact that he is the head of the state. And how did all of this happen under his watch? I think even further than that, Shadrach Sibiya's testimony is going to be very crucial, especially in terms of protocols. Were protocols actually observed? Were there documentation? Were the documented evidence, minutes in meetings where these high-level, impactful decisions were taken to show us the trail of how we arrived at the fact that Minister Mkhunu was able to legally and procedurally call for the disbandment of the task team.
Prof, thank you so much. You've really weighed in on a lot and summarized a lot of what happened. I want to hone in a little bit further because, yes, there are questions about who ultimately now needs to come forth and obviously answer to what has obviously been alleged. But let's look at that 121 dockets that have been transferred in March 2020, without informing the provincial commissioner. We obviously have to look at facts. We have to look at records. We have to look at why decisions were made, reasons as well. And I wonder if we're even just looking at the director for the political killings task team to be disbanded. I mean, we heard Van Rooyen say it was unlawful, was outside the constitutional mandate as well. And so when we're looking at authority, we're looking at, the different roles or the different players in terms of operations, policy and mandates as well. Talk to us about what was defied. Ideally, what are the normal protocols that would have had to be observed? How were they bypassed?
So I think, procedurally, the minister should have had a conversation with the PKTT to try and underscore or unpack their successes, against the original terms of reference, I would assume. And based on, whether they were actually being successful, effective, etc., I think that should have underscored or undergirded the decision on whether to keep the task team going or to disband. And clearly that did not happen from the public testimonies that we've already heard. So I think that was the first breach in terms of a procedural breach. And Liesl, we know that, historically, we know that many cases are actually, legal cases are actually, they fail because of procedural breaches. And here it's just very concerning that, people who come, or those who are responsible for taking care of our Constitution actually make these breaches. So I think that was the first breach that we saw happening.
Yeah.
But in addition to that, we should have seen a conversation, a meeting, a dedicated a legal meeting where minutes were actually taken, the correct role players were invited to the meeting, and that I think should have included the minister, the national commissioner, the provincial commissioner, and of course his legal team, so that his legal team, the minister's legal team, who would have advised him on whether any protocols or legislative frameworks were actually being breached. And I think we are not seeing any of this evidence. At this point in time, all we are seeing and hearing is that all of these protocols have been breached. So I think we're waiting to hear the other side. Any contradictions to the current evidence that has been provided?
I mean, beyond that, Prof, there's also issues about legislative oversight. I'm saying this because obviously even with Parliament's Portfolio Committee, if they've formally received warnings from, Lieutenant-General Nhlanhla Mkhwanazi or others about interference, their response in writing, to your point about emails, logs, meetings, anything to prove or disprove that. Van Rooyen was highly critical of Parliament's Portfolio Committee as well for not acting on these earlier warnings as well. And so when we bring the issue of legislative oversight, where do things break down? Where is communication also lost at this point?
I think, Liesl, at this point in time, listening to the evidence, it sounds like there were breakdowns throughout that chain. I mean, the fact that Parliament, the Oversight Committee was aware of this and seemed not to have acted in the best interest of the country makes us wonder, was that because of political interference? Was that because of lack of capacity? What was the real reason that they themselves failed to act timeously and effectively? So I think that's a huge concern for us as a country as well. What were the real reasons? So we're waiting for them to come and give us their evidence as well.
Yeah, and I mean, Prof, even just looking at Van Rooyen's concerns about iPad, right? The backlog, the proximity to the minister, the reforms needed on this front, especially when we're looking at watchdog bodies, right, who are supposed to be independent, they're supposed to be resourced, they're also supposed to be effective. I wonder if you could speak to those legal or constitutional reforms that are going to be needed to clarify the roles, perhaps to avoid future scenarios that we're witnessing also playing out.
Yeah. So Liesl, I mean, I think this is one of the groundbreaking commissions that we've had in the country. And I think at this point in time, it is so necessary because it's almost what the commission is doing is that it's investigating SAPS as a whole, and of course, including the criminal justice system. And definitely out of this, we're going to start to see reforms. We're going to have to see reforms in terms of the criminal justice system because it's a huge risk at this point in time, whether it's inadequacy, whether it's political interference, whether it's nepotism, whatever the reasons are, it's a huge risk. It's such a fragile institution at this point in time. So definitely, we're going to need reforms, and let's hope that the Commission makes those recommendations, reform at all levels, where we start to rebuild a really effective criminal justice system, not just SAPS, but an entire criminal justice system, including the tasks, the role functions of the Portfolio Committee in terms of oversight for, the legal oversight for SAPS and other similar departments.
Prof, and also just reasonable outcomes, right, for the public at large once this all wraps up. In interest of time, I'm going to have to leave it there. Thank you for your time at this hour and for weighing in. It's always a pleasure just to make sense of obviously what transpired and summarize what happened. The Madlanga Commission, it continues. The weights of the expectations are heavy. It's not just about answers. We're also looking at rectifying past failures and finding real accountability and reform going forward. Again, thank you to Prof Nirmala Gopal, UKZN criminologist, for weighing in.